So just want to formally welcome everyone again to Family Law Now's presentation on ethics and strategy in the legal profession, best practices for navigating divorce and separation. And thank you for tuning in. This program has been accredited by the Law Society of Ontario and contains 1 hour of professionalism content. So before I share a bit more about what to expect during today's presentation, we'd like to get to know our audience a bit better and understand who's joining us today. So as I go through, I'll just throw our first poll up here, and then Russell will share the results shortly. Okay, so just to share what you can expect over the next hour or so from our speakers, they'll be covering the following topics. So conflicts of interest, signing off on unfair agreements, losing objectivity, the 24-hour rule. They'll also be discussing when trouble comes, and it will come, responding to LSO and client complaints, failure to report potential LawPro claims, hiring experienced counsel when trouble or the LSO knocks on your door, and the role of mentors, colleagues, and community. And as Russell mentioned, we'll also reserve some time for Q&A. So now it's my pleasure to introduce our esteemed panel. Welcome and thank you to Brian Galbraith for joining us again. It's always a pleasure having you on the program. Brian is the owner of Galbraith Family Law, which has 6 offices in Ontario and 16 collaborative lawyers. Brian is the immediate past president of the International Academy of Collaborative Professionals and has served on its board for several years. Brian has helped train hundreds of collaborative professionals and conducted workshops on the international stage. Brian has served on the board of the Ontario Association of Collaborative Professionals and was instrumental in its formation. Brian was also the chair of the Trainers Committee in Ontario for several years and continues to serve as the president of his local practice group. Next, I'll introduce some of our team members from our firm who will be joining Russell to share their insights on this topic. So Golan Yaron is an associate family lawyer and a certified mediator with over 25 years of legal experience. He was first called to the bar in Israel in 1996 and then called to the bar in Ontario in 2003. Golan has extensive experience in representing clients in negotiation agreements as well as trial work. He also has experience in negotiating with the authorities to advance a client's interests and has represented clients at various levels of a court, including on appeals. Thanks for being here, Golan.
Thank you for having me.
And then next we have Susanna, and Susanna is also an associate family lawyer at our firm and is a fully trained in collaborative practice. She has over 11 years of family law experience and works hard to achieve favorable outcomes for her clients in their family law cases. Susanna approaches client consultations with a compassionate but analytical mindset and endeavors to provide her clients with the very best representation possible. She is also passionate about supporting local and international charities and humanitarian aid organizations, including World Vision International, ERDO, and the Salvation Army. We appreciate you being here as well, Susanna.
Thank you.
And if this is your first time tuning into our Family Law Now series, I'll take a moment to introduce our host and creator of the series. Russell is the founder and senior partner at Russell Alexander Collaborative Family Lawyers. With over 25 years of experience, he uses his knowledge and expertise to serve his clients in all aspects of family law and helps them in coping with the difficulties of separation and divorce, the division of assets, such as homes, pensions, and the calculation and enforcement of child and spousal support. He uses his experience to create unique solutions for each of his clients to enable them and their families to move forward and supports them through the transition of divorce and separation. And Russell has also written 4 books on separation and divorce and is a fully trained collaborative practice lawyer. He also spends his time speaking at conferences on collaborative practice, marketing, technology, and the law. So on that note, Russ, I'll pass things over to you for our next poll and to share some of the results.
Well, thank you for those kind words, Shannon. Great introductions as always. So let's find out who our audience is today. And thank you everybody for participating. So who do we got here? Family lawyer, 52%. Good turnout from the bar. Thank you for being here. A lawyer in another area, 29%. Financial professional, 10%. Law clerk, professional in another field. And let's go to our next poll. So we'll go back to back with the polls here, and then we're going to make a start. So the next question we have for you is, how often have you been asked to represent both sides of an agreement in a family law matter? Which is interesting. We're going to have a good discussion on this in a moment. Today's topic is ethics and strategy in legal practice. So what we're going to do is give you our perspective and insights into some of the rules of professional conduct you want to be mindful, some of the strategies you should deploy when practicing family law. Obviously, this is can be a very difficult area to practice with lots of minefields and things that can go off that you don't expect. So we're going to touch upon some of those today. If you want to share some of your experiences, please do and put it in the chat for us so we can share that with our audience. So let's see our audience results. Representing both sides of the agreement, never 35%, rarely 33%, regularly 27%, very frequently 5%. So probably, a third, Brian. Conflicts of interest, what should we be looking at?
Well, conflicts of interest, we always, before we even have a consultation, Russ, and I'm sure you do it at your firm as well, as we search our database because we've represented hundreds, well, thousands of people over the course of the years to see if we've ever represented one of the parties that's coming before us right now. And so obviously the policy is that if we've met with the other spouse or a person involved in the matter, the dispute, we won't meet with the person who's seeking to retain us. And so one of our obligations is we cannot tell them why. We cannot say your spouse has had a consultation a month ago or something like that. They just say, no, I'm sorry, we're not able to meet with you at this time. And
what do you do, Brian, for the ones who fall through the cracks? So I'm thinking, we have multiple associates as well. Maybe somebody used the maiden name, or we somehow missed it, and both clients are now retained with different lawyers in the firm. What do you do in that situation?
Wow, I've never never had that. I think we'd have to talk among ourselves. What should we do? One option would be to withdraw from representing both of them, really. That might be one option. Another option is for one of them to find another lawyer, but that we would still need them to sign a waiver of conflict of interest to allow us to represent the one lawyer. Otherwise, we would just have to withdraw from representing both of them. So fortunately, that's not happened to us yet.
We're very similar. First come, first serve. So if somebody's already retained us, the other spouse doesn't get through the door. But
right.
Occasionally.
One thing I do occasionally, Russ, sorry to interrupt, was that might be of interest is that I will meet with both spouses to talk about process options. And before I meet with both spouses, I tell them that this is creating a conflict of interest and that I won't be able to represent either one of them. So then I have a meeting with both of them, either on Zoom or in person, and I talk about, kitchen table, mediation, the court system, arbitration, and of course, collaborative practice. And I talk to them about the pros and cons of each process. And then I tell them, look, if one of you wants to retain me or our firm, the other has to get a waiver of conflict of interest signed by an independent lawyer to allow me the comfort to represent the one party going forward. I've done that a few times, and it's resulted in some collaborative cases. The clients appreciate being able to hear the process options, and I'm very clear, I'm not going to talk about the substantive issues, just the process options.
I've seen a bit of an evolution. Like 25 years ago, I'd always see one lawyer signing off on both sides of the agreement. I don't know if you've experienced this, Golan. You prepare the agreement, you sign off, and then your clients say, well, can't you just sign off for my spouse too, right? Have you ever had somebody ask you that?
Well, that was probably before my time as well, but actually an anecdote on that conflict of interest, I gotta say that because I had a situation where a client years ago told me that he had a consultation with like 10 lawyers just to conflict them out.
Yeah.
Oh,
which is just be aware of that it's sometimes happens in that area of law, at least in that. And I'm also wondering, Brian, perhaps the 30% that were indicating that they have been contacted to act for both clients. My speculation is that most of them are real estate lawyers. That's my take on it, because that is the area where there is still a allowance, if you want to call it that way.
And they're
Yeah.
acting for the bank too, right? So 3 people, but maybe the audience can put the comments into the chat and let us know. Susanna, have you come across this?
No, I have not, thankfully, and I don't think I am of the vintage where I'm happy to do that. I think I would just refer them out and avoid any future problems. That's just from my own sanity, though.
Well, I think it's prudent advice too, right? You want the agreement to be enforceable, and that could be a line of attack if one lawyer represented both sides and somebody got shortchanged. It could be a
Yeah.
LawPro claim, or it could be a superior court trial to have the whole agreement thrown out. So spend the extra $500-600 or whatever it costs to get independent legal advice and have the other spouse sign off on it would be prudent, but
Absolutely, and I think it's a lot of headache for the lawyer as well if that situation ever unfolds, because you want to put everything in writing, but some things you might forget about, or it'll become your word against theirs. And do you really want that headache? I personally don't.
Russ, there's one lawyer in Alberta who has received special permission by the Law Society in Alberta to have this project where she's meeting with both parties and helping them resolve issues related to family law. So she's representing both of them, giving them legal advice to both people, making recommendations for settlement, and then drafting the settlement documents. But the caveat is that both parties then have to get independent legal advice from a second and third lawyer to before they sign the agreement. But there's that's an experiment out in Alberta, and she says it's gone really well, and it might be something that we'll see happening in Ontario as well.
for the client, it kind of makes sense, right? Why do I need 2 lawyers? Can't you just do this? We're both going to pay you. We have limited financial resources. We're seeing lots of self-reps now. Why are they getting pushed out of the system? Because now they got to get 2 lawyers. Like, you can see why some people would get frustrated with that.
For sure, but the Law Society rules say that explicitly that we can't represent both parties in a family law case. So it's something to be very careful about, that's for sure.
All right, let's
Is
go.
it, Russ, is it cheaper though? I mean, in that situation, you have to have 3 lawyers as opposed to 1 each.
In what sense? No, I'm there.
Alberta, right? In that example.
Agreement and meet with husband and wife or whoever the spouses are and sign off for everybody, just 1 lawyer.
In the model in Alberta, you're right, Susanna, there is a second and a third lawyer, but their role is minute because their role is merely to give independent legal advice once the separation agreement has been created by the first lawyer. So I think the role she does it on a flat fee basis. So she's doing a lot of the heavy lifting, and then the last piece is that ILA. So I would think it would be a little bit less costly because her fees would be shared presumably by both parties.
Brian, tell us a little bit about some of the front end collaborative work you used to do. I don't know if you're still doing it, where you meet with both parties to discuss process, and then I guess there's one, then bring in another lawyer. How's that work?
Yeah, like I said earlier, that works really well. I meet with both parties, but I make sure they understand that it's creating a conflict of interest by the very fact that I'm meeting with both parties, and I won't be able to represent either one of them going forward unless one of them has a signed waiver of conflict of interest signed by an independent lawyer. And so that's worked really well, but we've had great success opening collaborative cases on that basis.
Yeah, and it gets them in the door, right? Like you get them into the collaborative process before they start off the road towards litigation.
Right, yeah, and absolutely. And, if they're willing to come to a meeting together, that bodes well for the collaborative process. It suggests that they're going to be cooperative and collaborative, and they want to work together to find a solution. So it's kind of self-selecting.
Yeah. All right, so let's go to our next poll question. How often have you signed off on an agreement that you believe to be unfair in a family case? This is interesting because we're going to have a good discussion about this, but I want to give our audience a few minutes to answer this question. We've got questions coming in from the audience. Thank you so much. One question is, can you represent both parties in a joint application for divorce? Susanna and Golan, what do you think?
Well, it does happen, especially nowadays when you have self-represented litigants. In my experience, it happened to me a couple of times where the first reaction is, if you're going to give away the farm, why do you need a lawyer? That's if that's your determination, to do something that is completely contrary to your best interest, or not best interest, at least to your interest, why would you be seeking legal advice? So I think the answer to that is that the other side insists you have an independent legal advice, so they are protected and having an enforceable agreement that, although the agreement seemed to be on its face unfair for whatever aspect, whether it's equalization or support or waiving other rights that you may have, I think that's where the pressure comes in, that the party that comes and seeks a legal advice, when he instructs you or presents you with a separation agreement that has already embedded some unfair terms to it, is because the parties want to have an enforceable agreement in place. And my first reaction was, you don't need me. You can go outside and just sign it in a parking lot. You don't need me to give you advice. When the insistent comes in and you recognize that you're dealing with a normal person, let's call it that is aware of his rights and obligation, etc. The best thing to do is, at the end of the day, what is the independent legal advice? Is to say exactly that this is not my recommendation to you. The rights and obligations are 1, 2, 3, and it's not falling into the framework that we are taught and been practicing in Ontario. So in that respect, I don't think that we need to shy away from that completely if you are documenting it very, very firmly that your recommendations were against the signing of this agreement, and it's not in your view, a fair agreement to the parties. But nevertheless, if you read the certificate of independent legal advice, it says that the party has been made aware of the consequences and the terms of the agreement, and is not going to be saying, I did not understand what was said in it, So that's really what is this. This is what the independent legal advice is for. Having your name on a contract like that, I don't think that's not a best idea, but sometimes it's necessary, because when parties are adamant that this has to be completed with independent legal advice, so it's something that is recognized as enforceable, that everybody had their opportunity to completely have an informed decision on whether or not they should be signing this. You have to weigh the cons and pros in a situation like that, and decide whether you want to have your name attached to that agreement.
The question was joint application. Susanna, would you just proceed with an uncontested application, or would you sign off on both parties if the joint application, say, for divorce?
No, never. I tend to practice very conservatively, and I do not want to run into a situation where, my file has to get produced or a judge has to look at my release that I had the client sign or anything like that. I think that's just more of a headache than anything else. And I make it very clear to clients from the very beginning, I will not put my name on an unfair agreement. You're free to take it to another lawyer. It won't be me.
All right, let's see what our audience says. Never 58%, rarely 34%, regularly 7%, very frequently 1%. Well, this takes us into our next topic. Golan and Susanna touched on it a little bit, but signing off on unfair agreements. Brian, what's your take on this? Would you do it, not do it? I know there's lawyers who will charge a premium, 10 grand, $12,000, say, sure, I'll sign anything. I'll sign off on it. And the premiums to cover their LawPro deductibles if they ever get sued. Sort of prepayment of that, because if it's, $700 for independent legal advice and you're potentially going to get sued, it's not worth the risk. But if you can pay me $12,000 to sign off on it, sure, I'll sign off on it. But I think you have a kind of different take on this, right, Brian? People can make bad agreements.
Yeah, our primary value at our firm is to treat others the way we would like to be treated. And that really means respecting clients and respecting their wishes. So I feel like if a client is not impaired, and I mean, not only not impaired by alcohol, but not impaired by their emotional state or mental state, and they're seeing things clearly and understand the implications of what they're doing, and they understand that it's a bad deal for them, I will sign off on that agreement. That's how I deal with it, because I respect my client's right to make a bad decision. Mm-hmm. And I'll even put in language into the separation agreement to say that my client was advised to not sign this agreement, but chose to go ahead with it voluntarily, just partly to protect myself and to make it very clear that this is not a great deal for my client, or it's in fact a bad deal. But I'll sign off on it because I would want to be treated that way. I think people have a right to autonomy and making their own decisions, and I don't think that it's my role to prevent them from signing an agreement that they can live with.
Yeah, and lawyers are all over the map. The late great Phil Epstein would say he was not going to put his name on a document he thought was unfair. For me, a lot of it's context, right? If I've been working with a client in a collaborative setting and I've got a family professional and they know the consequence of the deal and what they're leaving on the table, sure, we'll sign off on it. They may be doing it because they don't want the emotional toll, the process going on, or they want to resolve an issue. And I think Brian's right, you got to respect that. But if I have a client, perhaps her spouse drove her to the office, she's clearly upset, I'm concerned about duress, the agreement is fundamentally unfair, maybe a pension's not valued, or there's missing information that affects my ability to give proper legal advice, I'd probably say no. We want to you can still sign off on it later, but we need a proper pension valuation so you know what you're walking away from. And so I think a lot of it for me is driven by the context. I respect some lawyers don't want to participate in that. Other lawyers are all in. You pay their fee, they'll sign it. And then you've got everybody in between. So really, really great discussion. Let's move on to losing objectivity. We always see lots of lawyers who start emoting their clients' behavior. And, they're acting like it's their issue or their argument, either in the collaborative setting or especially in court. That's always, that's a red flag for me. I remind counsel that they're there to be advocates. This is not your fight. They have this idea that they're the warrior, or they're there. This is their image of being counsel, sometimes taking unreasonable position. You mentioned dirty tricks, Golan, where clients shop around. This especially occurs in smaller communities, and meet with the more prominent lawyers to conflict them out so their spouse has to go out of town or cannot use local counsel. There's also clients who sleep with their counsel, right? And I can think of 2-3 lawyers who've been disciplined. One has been suspended, one was disbarred. Third one got off the record and another lawyer completed the case. But that's, you know, if you're sleeping with your client, it's probably a breach of the rules, and you're no longer providing dispassionate, objective legal advice, you're providing passionate legal advice. But certainly there's lots of other ways that lawyers lose their objectivity. What do you think, Brian?
Yeah, you're absolutely right. And it really, I think, is a disservice to your client. I think it's unethical when a lawyer loses their objectivity. That's just not professional. I think that clients are paying us to stand, you know, apart from the whole action and to give advice from a distance. You know, I went through my own divorce, Russ, and I hired a lawyer, even though I'd been practicing law for, I don't know, 15, 20 years at the time, because I wanted someone who was not involved in this situation to give me their objective opinion and advice and support. So I think you're really acting unethically and unprofessionally if you lose your objectivity.
And I've seen lawyers do their own trials and it never goes well. There was a lawyer in Lindsay that had some mental health issues. I offered to help him through it. He's literally writing his pleadings out in the library at the courthouse. It looks so poor in the profession. Another lawyer I know in Durham ran a 20-30 day trial against his wife. You know, it's really, you know, you're your worst enemy when you do that, right? You're litigating for other reasons. It looks bad on the profession. There's no sense of objectivity. You just happen to know the rules. And I think judges really rein those lawyers in who try to self-represent. But Susanna, what do you think of objectivity?
I think it's really easy to lose it. You know, family law is one of those things where tensions run high. Lawyers are stressed out, and some of us take the client problems at home. Some of us are better able to disassociate ourselves from it, and we need to take these breaks too, right? We need to have do some self inspection and know the key factors to look for when we think that we're losing it, when we think we need to step back. We need to rely on our colleagues and have conversations with other lawyers. Hey, where do you think I'm going wrong? What can I do better? Do you think I'm losing it? You know, sometimes that's what our colleagues are there for, because when we get too involved and we take on the stress, and you know, the stress varies on the files that we deal with. Our colleagues can maybe help us see things that we're not seeing.
Right.
And I think we need to rely on them more than we currently do. We try to do family law by ourselves a lot. A lot of us do that, and it's a mistake.
Yeah. In the bigger firms, it's easy, right? You can call up an associate, or we have a meeting and bounce problem files and problem judges and problem lawyers off each other. Smaller sole practitioners don't have that luxury, and sometimes you hit a wall, right? You've been litigating a case for 2-3 days, or you're in 3 days of questioning. You know, that's physically draining, right? And you can see how it pushes you to the edge a bit, right? So, Golan, any take on objectivity?
Well, firstly, just to continue your point, that's exactly, I mean, one of the topics that we have here is the mentorship, and that really ties up to that. We'll talk about that later. But in terms of losing objectivity, the way I see it is that sometimes there is an intentional practice of, I'm just being a mouthpiece for my client, and if that's what they want, I'm not second judging their reasonableness. So you feel like what do I need you for? I might as well deal with your unreasonable client. It doesn't help the case. It doesn't promote it. It doesn't move it forward in any way. So I think that on the one hand, when a lawyer feels that, well, if I'm only saying what my client want me to say, I'm protecting myself. But I don't think this is really a disservice when you're looking at your role as a lawyer to give advice. And I sometimes play devil's advocate with my clients just to tell them this is the counter argument. This is what my this is what my prediction in terms of how things going to turn out on this topic or another. So I think that's part of the professional obligations to provide an objective view to your client, even if it sometimes does not fall on favorable ears, because sometimes they feel like, oh, I'm paying you to do this, then you might as well just do that. Otherwise, I'll go elsewhere. I don't buy into that. It's like this is not the way that I practice. If I feel that it needs to be said, then it has to be said. It's not something that you have to hide just because the lawyer is paying you to say something or move in a direction that is not a reasonable direction.
There's a lot. There's a lot there, right? Like the client should not be hearing about bad news for the first time from the judge. The lawyer needs to tell them that in their office privately before you get into a hearing or a collaborative setting. Lawyers, this is a bit of a pet peeve. Lawyers often write letters for their clients. They're not writing it for us or to identify or narrow issues. They're juicing it up. This is going to push the clients, make the client feel good, right? And they're setting traps for other counsel too. Like it's almost like we went to school and learned how to write nasty letters, and everyone's really, really good at it when they want to be, and it creates this bit of a black hole, right, where everybody gets drawn into this letter writing campaign, and we've all been part of it. But that kind of leads us into this next topic, this 24-hour rule. Susanna, what are we talking about?
That's a really expensive degree, Russ, if we go to school to learn how to write nasty letters.
It's a side effect of the law school environment, or the traditional model of litigation. But yeah, maybe it's an unfair comment.
No, it probably isn't, but you're right. We often hear pick up the phone. And when you pick up the phone and you talk to another lawyer, you realize you could settle a lot of the issues. But sometimes we're scared to do that too, because then you have this disagreement.
There's just one other thing. I forgot about this on objectivity. Be very, very careful representing family and friends, right? This is another thing we overlook. You're not being objective anymore if you're representing your best friend or your brother in court. And I think some judges have actually refused counsel to act for family members. So that's another thing we want to be mindful. Sorry to interrupt. I just want to add that point in, but go ahead, Susanna.
You may lose a friend. That's the way to lose a friend. Yeah.
Yeah.
Refer them out.
Yeah.
Yeah, I think a lot of conflict can be solved in family law by simply picking up the phone and talking to the other lawyer. But a lot of lawyers are reluctant to do that. I am one of them. And the reason is that we feel like we can't trust other lawyers, right? And so you pick up the phone, you talk to them, you have a nice discussion, and then you try to put in writing what you talked about, and then there's no agreement on what you talked about, and then the file becomes more litigious than it needs to be. You're right. We do write letters for our clients. We don't necessarily write it for the other counsel. And the clients expect us to defend them, be their best advocate in a certain way. And they expect a certain level of aggression because, they think that's what they need. But I think it's our job also to say to them, let's take a breath, let's breathe, let's look at this a different way. Because when another lawyer receives that, or the other party gets that, how are they going to respond? Is that what you want? How do you want to settle this? What is your best outcome? And how can we write this letter in such a way that we achieve that goal. Because at the end of the day, when the lawyers walk away, the parties still have to coexist, especially if there are children involved, right? I always say we attract more flies with honey than we do with vinegar. That doesn't work for all clients, but it's true nevertheless. I think the 24-hour rule is a good one because it's very, very easy to respond in kind. It's very easy to get upset, especially when you have one lawyer who is just spewing or mouthing whatever their clients want them to say, but the other lawyer has evidence to the contrary, right? Personally, I've realized that when I step away and I take a little bit of a break, or maybe I work on another file and I come back to this one, I see it in a different light. I think about something I never thought about before. I think about a new strategy, which I can then discuss with my client. But in the moment, if I had responded, it would not have been the way it should be. And it's very easy to step over the line and breach the rules of professional conduct that tells us we have a duty to be courteous and civil, right? Even at the last the summit that we just did, judges talked about how we are supposed to be kind and we are supposed to be helpful, especially when there is a self-rep. I've had judges who appreciated the fact that I was kind and I was helpful to a self-rep, and that goes a long way in helping your clients too. So whether you deal with opposing counsel or self-rep, it's important to remember that rule and to just take a step back. It's not always something that we do, but maybe we should have like a bumper sticker or something on our desk to remind us, because the stress takes over sometimes and it's unfortunate.
Well, the old days, you dictate a letter and it come back to you and then you say, oh my God, did I actually say that? But now lots of us are working, put the kids to bed, we're working 9, 10 o'clock at night, responding to emails, maybe had a glass of wine, and you're firing off these emails without that waiting period, right? Because technology, lots of counsel communicate by email. I don't think people send faxes anymore, or regular letters. So for me, every time I've asked a clerk or a lawyer to hold a letter and I look at it the next day, I always change it. Something always comes out. There's always an aspect of it. It's a little bit too sarcastic or is not going to help move it forward. But Golan, and we see this in minor hockey and other sports. Don't talk to the coach. If you're upset about little Johnny's ice time, wait 24 hours and the next day you don't really care anymore. But in the heat of the moment, everybody's fired up. But Golan, what do you think of this idea of waiting 24 hours or putting a filter on your email so that everything doesn't go out instantly?
Firstly, it's always a good idea to really think what your instinct tells you to do. But one of the flags that I use is, and many lawyers still do it, I don't. When I write a letter to another counsel, I don't put CC client. When you put CC client, I know you're writing it for your client's eyes and you're trying to impress or do something that justify your existence. That's not, so I take it with a grain of salt when I see a letter that may be a bit aggressive or try to intimidate, because some of the assumption is that letter will go from me to my client, which I also don't always. I'm the filter for that communication to my client. I will let my client know the essence of what is being said, but I would not let that be the intimidating tools to my client, because then I'm the barrier here. I'm the one that's blocking that, and that's the reason that a client had me, right? He wants me to protect him. That's the protection that I afford when I'm able to actually be the barrier and not just let communication flow freely between the other opposing counsel who may be nasty or intimidating or have some ego issues that he's trying to impose on the other side. So the 24-hour rule, for me, I'm looking at it like you have to try to detach yourself from the file and not take it personally. But we're all human. I'm not saying that we cannot all ignore everything. Sometimes they need to be responded, but you know, you can do it in a manner that is professional and intellectual in nature, and you don't have to step down to that level of other counsel who may just don't have any filter and just fire away whatever they don't have a filter between their brain and their mouth kind of thing, or the keyboard. And yeah, that's the way to go.
We got some great comments. Thank you, everybody, for submitting your comments. One says, always remember that the judge is going to read it. Yeah, and you're going to look like a schmo in motions court when that letter you regret is read into the record. It used to be called the Globe and Mail test when you want it printed by the press. Yeah, that's a good point. I tell clients, do you want you want your mother, your grandmother reading these text messages, or your church? But Brian, 24-hour rule, what do you think?
Well, I just wanted to point out that, you know, these issues are all shades of gray. You know, I see Golan's point about not just letting correspondence go directly to clients. We take a different view at our firm, and we believe there should be complete transparency. And so communications that come in are automatically sent to the client so that they see them exactly as they're presented. But I understand why you're doing that, Golan. It's just we have a different approach. We feel that our job is not to be a barrier, but to provide advice and support so that the client can make their own decisions going forward. The 24-hour rule is essential. I make it a rule for not only business, but in my personal life. You know, if you get that knee-jerk reaction, your brain is taken over by the amygdala, and you're out there to protect yourself, to defend yourself. And when you have the 24-hour rule in place, it allows the brain to settle so that you get your prefrontal cortex engaged once again, and be rational and make a judgment as to what's right for this situation. So I think it's a really, really good advice. So I try to follow my own advice as often as possible.
Yeah, like I've received letters where I know that it was designed to upset my client, right? It's delivered on some kind of special day, maybe a birthday or some kind of event, and it doesn't move the dial. So I will indicate to the client, we've got correspondence here, but we're going to talk about it next week, just so it doesn't blow the weekend or the family event up, right? Because that's, you know, sometimes it's designed to do that. But okay, so we talked about the 24-hour rule. I think it's a great practice tip. If you're not sure, wait. You don't send it. Don't hit that send button, or ask a law clerk or a colleague, or phone one of us up and ask us, and we'll give you our opinion as a mentor. So when trouble comes, and it's going to come, you know, if you're in this game long enough, something's going to happen. Golan, what do? You know, you can get in a dispute with a judge, complaints. What's your recommendation? I think you're muted. Sorry.
Apologies. Yeah, thank you for that topic. Especially when dealing with the situation in court, that sometimes, you know, the tones go beyond the acceptable, and you may be, you know, some judges have you know, hot temper, if you want to call it that way. But in a pissing context like that, you're not going to win. And the problem is, and we used to say something back in my old days when I was in the army service, when a soldier wanted to rebel against the army, we used to say, you may piss on the army and it may get wet, but if the army pisses on you, you're going to drown. So in a similar fashion, you have to look at the powers here, in a sense. And there is power when you're dealing with a bench, and eventually the one who's making the decision is going to be the bench and not you. So you have to be mindful and perhaps diffuse such a conflict when it arises. It doesn't mean that you have to just take everything that's being thrown at you, but there could be ways to respond in a polite and respectful manner, even if it means to say to a judge, there's no reason to yell at me or something to that effect. That would send the message out that maybe it's time to take a break, maybe it's time for a pause, or maybe even ask for a break to let the blood go down to where it's supposed to be. So that's what I think. I think it is also correct with clients when sometimes you get into a conflict, and it's not going to be a win-win situation where there's just going to be a yelling contest or anything of that sort. Either you're going to lose the client and then end up with complaints, etc. And so it's going to suck up your time even more and more energy and more money. It just can snowball into such a drama that you really want to avoid that. And that's part of your interpersonal relationship with your client, how to try and diffuse the situation like that, even by involving a colleague or asking for your clerk to be present in the conversation, that sometimes just by virtue of another person being in the room, it takes the animosity down a bit, because now the animosity is not against that third party, it's just between you and me, but yet there's somebody else there, and we feel that we have to kind of give him more respect. So that's my take on it. It's really, I don't think it's not a legal issue as much as it is a psychological issue, but that's part of the behavior that we sometimes have to face either in court or in our personal lives or with clients.
I think we have a great bench. Sometimes judges are entitled to a bad day, right? It happens. But Susanna, what do you think of this discussion?
I think we should listen more than we should speak in family court sometimes, because judges pay attention not just to the raised voices and the yelling and the speaking over other counsel, but they pay attention to body language too. And at the end of the day, they're the ones making the decision. You may not like it, but that's something you have to prepare your client for, right? It's part of our job. And they have the final say. So we are allowed to ask clarification questions, and I think judges appreciate that. We should use it more often, because sometimes, they make recommendations and you don't know why or how, or you're confused. Your client is going to be upset, and I've asked before for an explanation or clarification, because I want to be able to make sense of their recommendation so I can take it to my client, even though I know my client's going to get upset. It's just not a battle you could win. It's not worth fighting. It's not worth losing your reputation over. I mean, I've heard that judges make complaints to the Law Society about lawyers. Thankfully, I hope it never happens to me. But that's your reputation on the line, right? You spend years and years, decades even, building it in this profession, and it's so easy to lose it. So guard it.
Yeah. Brian?
Well, I think one of that we could go back to the 24-hour rule. I think it's a good idea that if you're triggered by a judge or the other lawyer or whatever, that you take some time as much as possible. And one of the things that I would recommend is that you reach out to a colleague, maybe someone within your firm or someone senior in another firm, and people will take these calls even if there's no benefit to them, because there is a really good collegiality among lawyers in my experience, at least in Simcoe County and York Region, that people really want to help each other. And so I would call you, Russ, if I was triggered, and I'd say, Russ, this is what's going on.
Yeah. That's a great tip. I probably won't know the answer, but judges gossip too, right? They have lunch in chambers, and they tell if they have, we were talking when we were preparing this case, the judge made a decision that unfortunately resulted in a tragedy in a family case, and somebody else complained about that decision, and that person was a lawyer and basically got into a huge dispute with the judge. It didn't go well, but they gossip. And like just recently, I had a case management judge tell me he had to remind counsel of the rules of professional conduct, and that he could file a complaint about how they're conducting themselves in court, because it was like the wild west. They're talking over each other, they're not being courteous to the process. But sometimes, you know, especially when you're in a heated trial or motion, things will go sideways on you. And it's important that you stand your ground in a civil and respectful way. So if the judge is raising his or her voice inappropriately, that could be very intimidating to a client or a witness. You need to say that, Your Honor, I understand that you're raising your voice right now, so the record reflects the conduct that's occurring on the bench. If you're not being allowed to complete your submissions or given an opportunity to make submissions, and it's appropriate for you to do so, you need to state that on the record. I've seen situations in court where the court registrar is making recommendations to a judge in terms of an outcome. And senior counsel had to remind the judge that submissions should be limited to counsel only. So if there is an appeal, or if it goes to the judicial council or a complaint is made, you have the transcript, and the transcript will identify where things are going sideways because you're stating it to the court. And they can also order the audio recording and listen to the conduct of the hearing of that judge in particular presided over. So certainly, you know, you want to make sure that the record is clear in terms of the treatment you and your client are getting if you think it's unfair in some fashion. 24-hour rule is great, talking to other colleagues. Even if you ask the judge for a break and you phone somebody up, or you go down the hallway and find a colleague in the library and say, this just happened, right? Is it me? How do I respond to this? And get some advice, or even call the Law Society, call the practice advisory, and they'll help you through it. So really, really important topic. Let's go to our poll, next poll, because we haven't heard from our audience, and we do have some fantastic questions coming in that we're going to get to. So thank you, everybody. Have you ever faced a situation where you had to respond to the Law Society complaint? We got such a fun topic today, right? Everything we don't want to talk about, we're talking about. But so we're going to get to that in a moment, but let's go to one of our audience questions. All right. How do you navigate or deal with a family law client that presents unrealistic demands on you, given that the matter can be sometimes emotionally driven? Yeah, like we've all had clients calling Friday night, Saturday, you know, who wants to take this one? Brian?
Sorry, what was it?
A client that presents unrealistic demands on you.
Oh yeah, the first question. Yeah, that is, managing expectations is really key to a successful practice, and it starts from the very moment you have a consultation, and making sure the client understands what your expectation, their expectations should be of you and your ability to respond and focus on their case. And also throughout the process, you've got to tell them black and white when you can what the likely range of outcome will be. And that sometimes clients don't hear you, right? They're deaf to your advice because they're so focused on achieving a particular goal. Maybe it's vengeance or something, you know, they want revenge for being hurt by their spouse, and you have to explain, look, that's not going to happen in this court, or in any process, whether it be mediation, arbitration, or collaborative practice. Vengeance really is not going to work, and it's not going to be not only it's not achievable, it's not helpful. It's not helpful to getting the matter settled. So yeah, absolutely. you have to keep hammering home, and it is still hard, Russ. There are some clients that continue to hold on to unreasonable expectations, and sometimes you even have to fire a client if you're not able to manage their expectations, because they're the ones that do launch a complaint with the Law Society. So it's a very good question. It's
Let's
a
hear,
big part of practicing.
yeah, let's see our poll results, and that's great advice, Brian. And Golan, an audience member indicated they liked your army analogy. We've got more great questions we're going to get to. So responding to LSO complaint, yes, 38%, no, 62%. Wow. You must be doing something right out there. What do we do? You know, Brian, I remember the first complaint I got. I'll talk about it. It scared the crap out of me, right? It's like, oh my God, my career's over. What's happening? Well, what do you recommend? You get a complaint from the Law Society. What are you supposed to do?
Well, first of all, if there's issues,
Or I
you
guess
need to.
maybe a complaint from the client and it's Law Society wants a response, right?
Right, yeah. So the first thing is to talk about it with your colleagues and not shy away from it, and get somebody to help you who's objective, and come draft a response to it. You know, I remember that I did get a complaint many years ago. My first complaint was just rocked me to my soul, and I was just shattered. I can't practice. I'm going to be disbarred. Oh my gosh. You know, and on and on and on. And it is a scary proposition, because we depend on this license for our living. But I just made an honest and detailed response, explaining myself, and it went away quite quickly, and I was grateful for that. So don't shy away from it. You can get in more trouble by not responding. You know, and that's certainly a bad strategy. So respond in honesty, respectfully, and in a detailed manner.
And it's easy to procrastinate on this, right? Like, I always confer with the law clerk and get a detailed summary in terms of the specific complaint the Law Society's identified. And I think you need to normalize Law Society complaints. So this is part of the practice. When I got my first complaint, I called up a mentor. He said, "You've only got one? You know, you're a busy family lawyer. You're going to get 2-3 complaints a year, because that's the nature of the work we're doing. You know, we're kind of hanging on to this tiger by the tail and being the client, and every once in a while it's going to turn around and bite you. They may be upset with an outcome that you had no control over, and they're going to lash out and make a complaint." In responding to the Law Society, respond sooner or early. Try not to ask for an extension. Get the answer out to the Law Society as soon as you can. Emphasize your legal strategy, right? What was the strategy you were deploying when you were delivering that result to the client? Paper your file from day one, confirming your client's instructions. And then when the complaint comes in, you can say, here's my email to the client confirming this was the instructions to proceed with this particular motion that ended up not going well, or whatever the case may be. Always be overly polite in your correspondence. And remember, the Law Society is probably going to read it if there's a complaint. And my final tip was, don't embarrass the profession, right? But Golan or Susanna, you guys want to jump in on any tips for responding to Law Society complaints?
I think one of the issues sometimes that you have to kind of recognize is, firstly, I hear not quite often that the complaints coming from opposing parties, opposing self-litigants, in fact. That actually tells me that you were great on doing your job, because obviously the other side did not like you. That's the one topic. But again, you respond to it exactly as you said, timely, with details, and you know, when the right picture is before the adjudicator, they'll come to the right conclusion. With clients, in fact, you have to think about the motive behind it, which is many times it's about extorting their money back. It's a quick way of saying, hey, if you don't pay me, this is what I'm going to do to you. If you don't pay me what I'm asking you to pay me in return. Sometimes I find that from what I hear is that the Law Society would give them the direction to go for an assessment, etc. But that obviously takes them the long route, and they try to get a shortcut by getting that pressure or leverage over a lawyer. The same strategy as you indicated. It's each case is different. It may be something minor. It may be something more significant that you have to deal with professionals that would be of assistance. Somebody who's familiar with the in and outs and the process. It's not, as Brian indicated before, you don't want to be emotional dealing with it yourself.
Yeah. Susanna, anything you'd like to add?
I agree with those comments. I remember my first complaint. It wasn't from anybody but the opposing lawyer.
Oh yeah, I remember that one.
And I freaked out. But thankfully I had the paperwork and the documents to back up.
You thought they were trying to intimidate you, right?
Yeah, they were, because I was a new call back then, right? Maybe a couple months out. But I had everything to back up everything that I was saying, and the Law Society told him that he didn't have a case. If he wanted to appeal their ruling, he had 90 days to do so. He didn't do it, but it was very, very intimidating at the time, and quite stressful.
Yeah. Let's go into, we're going to go past an hour because we've extended the program, but let's get into the next topic, which is LawPro claims. And Susanna, we're back to you on this one.
Yeah, I think it's important to deal with LawPro, respond to LawPro on time. You know, I found LawPro can be quite understanding. The last lawyer I was speaking to said to me, you know what, Susanna, I understand. I've been there. I've practiced for 30 years. I've made mistakes too. We're here for you. But we are scared, right? Because we don't want our insurance premiums to go up. We don't know what's going to happen. But one of the things she said to me is, we look at damages. What's the damage that has been suffered? Can we assess that? Is there any damage that has been suffered here? So I think, you know, it's important to contact LawPro, do it in a timely manner, because they will ask you, when did this happen? And they will walk you through it. I think sometimes we just need that reassurance, you know, they're here for us, they're not against us. And once we have that reassurance, we would feel a whole lot more comfortable talking to them. But it's important. It's important to let them know what's coming down the pipeline, what's on the horizon, what's going on with your practice, and be honest and upfront about it.
My understanding is, as soon as you think there might be a potential claim, you have a duty to report. You go online, click a button, and it's reported because they want to mitigate damages. And if you don't, it could violate your insurance. Brian or Golan, do you want to say anything about LawPro or any tips?
My understanding is that, like Susanna indicated, they're on your side. You have to cooperate as soon as possible, provide the details. The whole idea is to provide a defense or preventing a litigation before it happens. So the idea is to really be frank with your LawPro insurer and do the right thing.
Yeah. Brian?
You mentioned earlier to really paper your file, and I think that's excellent advice. I think you can more often successfully defend a LawPro claim if you've got paper on your file indicating the advice you've given, the steps you've taken. And there's lots of different ways of doing that paper. It could be in notes that you take, handwritten notes that are input into your systems. We use Clio, so it would be notes into Clio, or it could be even the dockets. We use really detailed dockets that help to explain our actions and our conversations and our advice and so on. So it's really important that that's your best defense, is to be able to rely on the paperwork that you've saved, because hey, let's face it, we have hundreds of files over the course of our career. Sometimes it's hard to remember the details of what was said and done along the way. And it may be that you made a mistake, in which case you have to be accountable for it, but it may be that you didn't make a mistake, and you can prove it through your paperwork.
Yeah, we're going to get to everybody some more questions in a moment. 2 more topics to cover. Second last one. Like we were talking about earlier about the lawyers who represent themselves in their own divorce. You don't want to be one of those lawyers if you're dealing with the Law Society or a LawPro matter. LawPro is easy. They'll appoint a lawyer for you if there's potential litigation, or they'll appoint a lawyer early on to take a look at it. So that's covered off. But if you get a Law Society complaint that's not most of them are just summarily dismissed, right? If it's an upset party on the other side of the case, the Law Society is going to be very quick at dealing with that matter. But if you get something that's substantive that they may want to investigate or hold a hearing on, my advice is hire counsel, right? Just like you should hire counsel, like Brian hired a lawyer to handle his own divorce. You're going to get experience, dispassionate. They're going to know the workings of the Law Society and discipline tribunals. And most importantly, it's going to show that you're governable while protecting your rights and reputation and career, right? So one of the things the Law Society is concerned is if you're ungovernable, or if you're not going to follow the rules, or if you're not going to respond to requests for information from the Law Society, like Brian said, this is going to get you in more trouble. But if you have a lawyer representing you, and if they're making requests for information which may not be appropriate, that lawyer can object on your behalf and say, we're going to cooperate, but for the following reasons, disclosure of this particular information is not necessary, or whatever the case may be. So it's good to have those people in your corner giving you that advice. You're going to be incredibly stressed out. You're going to be very worried about, obviously, the complaint or the investigation. And you're going to have this lawyer act as your sounding board. It's going to cost you money, but in my view, it's just the cost of operating a business and operating a law practice. And it's a necessary cost, because you want to preserve your career and your reputation. Lots of great lawyers out there that do work specific to the Law Society Tribunal. A couple names that come to the top of my head would be Gavin McKenzie, William Trudell, Brian Greenspan has handled some notorious Law Society cases. Those are just a handful. There's lots more out there, but certainly get counsel if you have to go down that route. We're going to move on to mentorship, but anything else people want to add on this particular topic about hiring counsel if there's a Law Society issue that you need to address? Okay, I'm hearing crickets. So let's get to mentorship. Brian, role mentors in the legal profession. What do we need to know?
Super important. Now we have 18 lawyers in our firm, but in my early days as a sole practitioner, I used to rely on the other counsel in my community, and I would ask them for advice. I would ask them for precedents. I would ask them when an ethical issue arose, and every time people bend over backwards to support me and help me. And I pay it back now that I'm really old, and I give advice when I'm called upon, and I mentor people from time to time with their practices and help them make decisions going forward. So don't hesitate to reach out to your colleagues. They may sometimes sound fierce and unreasonable in court, but deep down they're a human being, and if you approach them with honesty and integrity and seeking their help, they'll step up to the plate in most cases and be there to help you. So I encourage, we have a good community for the most part of lawyers, and so take advantage of it. And when you're called upon, I encourage you to open the door and answer the call, respond to the email, and help out your colleague, because we're all in this together. We need to be able to do a good job for our clients and get on with life.
The Law Society offers a mentorship program. Susanna, what do you think of mentorship in the legal profession?
I agree with that. When I was newly called, I practiced on my own for 6 years, and I mostly practice in Oshawa, but I haven't had the experience of calling upon a lawyer in the Durham community and them turning me down, them saying, I don't have time for you, or, you know, just being totally dismissive. I had one lawyer who actually sat down at my desk, my computer with me, and went through an NFP with me. And I was so appreciative of that. And today, when I have clients that I think are a good fit for him, I send them his way. It's just another way of saying, hey, thank you. You know, I didn't forget how kind you were to me. And absolutely, I try to pass it on every opportunity I get. It's so fulfilling to help. Sometimes senior lawyers need help. Sometimes junior ones need help. It's something that we should continue to do. Pass it on and pass it along. There's so much. I always say, what I don't know is much more than I actually know.
Golan?
Yes, I think firstly, mentorship, I think, is a privilege to be a mentor. I think it has to be appreciated that you have a responsibility to instill and educate, whether it's a new call or whether it's somebody who's in a bind that needs some assistance and guidance on. Maybe it's a conflict of interest case that he needs to have another opinion on. Maybe it's a complaint. Maybe it's anything else. I think that it's our duty as senior lawyers, those who've been in practice for a long time, to help out. That's our give back to the community, to the professional community, and we have to share our experiences, you know, and that's the best we can do to get this profession become better. And instead of lawyers writing nasty letters to each other, maybe this will share the love, as I call it. Just have to spread the karma there, and this is one of the good things that we can do for our profession.
Russ, one quick comment is, you know, there's a Facebook page of Ontario Family Lawyers, and people pose questions on that all the time, and it's just amazing how many people jump up and are there to help one another, providing precedence and advice and opinion, and they freely take the time to support each other. So there is a pretty good community around here.
And even participate in events like this one. Everybody's volunteering their time. We're sharing our experiences.
Yep.
What?
We're telling you you're going to be okay, right? I've had some lawyers say, you know, they've got a particular issue, or their lawyers are always scared the first time they go to trial, right? Like, and lots of people do not do trials because it's just too much. And I say, you know, I'll come and sit in on your trial. I'm not going to charge you or your client, and we'll walk you through it. And I've done it several times. And every time I do it, I tell the lawyer, you've got this. And when they go to trial, they do have it. They just needed a colleague there just to get them through the first day or two. Day 3, it's like, okay, you can go now. I don't need you here anymore. But it's just getting over that hump, right? That I'm not good enough, you know, imposter syndrome that plagues everybody in the profession. And mentors help you get over that hurdle. It's a great practice and tradition in our legal profession. So thank you, everybody, for being here. I see Shannon's showing up with the hook, ready to pull us off the stage. But let's get a couple questions in, Shannon, if we have time.
Yeah, sounds good. Want to be mindful of everyone's time, but we do have the last couple questions here from the audience that we want to get answered. So one here we have is, how do you deal with opposing counsel who threatens your client by saying their client has unlimited funds backed by the family and will litigate until the end, as your client has limited means and probably can't afford a lengthy litigation?
The client may not have, the client may have may not have limited funds or no money, but the lawyer doesn't. I've seen lawyers take on cases pro bono, or they'll wait to get paid at the end of a trial. There is services where you can get litigation financing now to finance cases to deal with this imbalance. Or you can go to court and get a judge to make an order that some costs be dispersed in advance, litigation costs, which are quite, and the judges want to even the litigation playing field. So if somebody's got $1 million and the other one's destitute, they may order that $100,000 or $200,000 be dispersed for legal fees or expert fees. So it's more common than you think.
You can imagine, Russ, you can imagine putting that letter before a judge when you ask for the disbursements.
Yeah, that's right.
Right?
You're going to be pretty motivating to do justice and make it a fair process.
And then just last question here, how much detail should be put into dockets?
Brian, you were talking about that a few minutes ago.
Yeah, I think dockets should help tell the story of what's going on. So it's a summary of the activity. You know, sometimes lawyers will put something down simple like wrote a letter to opposing counsel. That's not helpful because that doesn't tell the story of the activity. So you need to describe the activity and the contents of that activity. So you don't want to make it maybe, you know, 10 sentences long, but maybe 3 sentences so that people can identify that activity and distinguish it from other activities.
Yeah, and you know, dockets is another opportunity to communicate with your client. You communicate through reporting letters, through emails, through phone calls, but this is a chance to communicate, right? And I would docket and bill regular and docket unbilled work. Say I did this work and spent 2 hours doing this research, I'm billing you $0 for it. So the client knows all the time that you're putting into it. And most importantly, if you get assessed and you have detailed dockets, or if Susanna had this recently, you have a bill of costs, you have very detailed documents in terms of what the entry represents. It really makes the bill bulletproof at that point. The client could have complained 6 months ago that that work wasn't done, but it was detailed. I see you nodding your head, Susanna. You've had quite a lot of success with this, right?
Yeah, I mean, in that file, the judge actually commented on the quality of work that was done. And part of that was reading the pleadings in front of him, sure, but also seeing the very detailed dockets, you know, 4 or 5 lines long for each entry in the bill of costs. So it really helped the judge when he was making his cost award. You know, I wouldn't put things in there like formatting or converting from PDF to Word. I see those things sometimes, but they're not appropriate. Tell the story. And always remember that when you docket, a judge could read this at some point in the future. And if a judge reads this, would he get an understanding, a fulsome understanding of what you did?
Yeah. Let's end on a high note. There's a good question came in here. You know, this has been such a dreary day, but I think everything we've talked about has been hugely important and helpful. But Shannon, a nice question came in. What was it?
I do love this question. It says, what's the most rewarding thing about being a family lawyer?
Pick your audience, pick your host, and we'll do a rapid fire here. Who do you want to start with?
Golan, what's the most rewarding thing for you?
Thank you for that question, whomever put it in from the audience. I believe that knowing that you set a client on a road, a healthy mentally and financially, and guide him through, you practically been a guidance of his next stage in life. And when they respect that and being grateful for that, that's the best part in my view of there. You feel that you actually made a difference in somebody's life. And it goes also to children that you might have helped them in setting them with the right parent and you know, for the right family, and it goes a long way because it's really a life-changing moments for these people.
What about you, Susanna?
For me, it's helping the client and by extension, the children. whatever form that takes. Sometimes I say to my clients, send me a picture of your child because I want to see who I'm fighting for. And the second thing for me is reading client reviews, because when you're in the throes of family litigation or collaborative or whatever it is, and you're in the stress of it all, you don't necessarily get a real appreciation for how the client feels. But when that matter is done and you read their review, sometimes you're just blown away because you have no idea what an impact you had on that client. And just reading that, it makes my week. So those are the two things for me. Thanks, Shannon.
Thanks. And I've seen a lot of great comments come in for you. So
yeah.
What about you, Brian?
My brother gets this question. He's a pediatrician, and he said, well, isn't it hard for you to deal with sick children? And he said, well, they come to me sick and I help them get better. And that's the way I see it in my practice, is when they come to me, they're at the worst point in their life and I help get them get better. And so that's really rewarding. And so I've been doing this for 34 years and I still enjoy it because I feel like I'm really making a positive difference in people's lives.
It's a really great analogy. Thank you, Brian. And Russ, we'll end off with you.
I absolutely love my job. I just love it. I love spending time with clients and hearing their story. I love the people I work with. I love meeting people in person. I love doing these events. In my view, that we're here to serve, right? We have an opportunity to serve the public, our clients, in our communities. We're in a very unique position to help these people. People come to see us at their absolute worst, right? Their spouse cheated on them. There's been domestic violence. They're going to lose their home. They're going to lose their friend group. They're going to lose their identity. They may not get support. What's going to happen to the kids? I see people go through physical changes after the file is complete. So we used to take photographs of clients and put them on. We have to identify our clients, and we stapled into the inside of the file. I had a client came back 18 months after her case was settled, said, I want to take a new picture. I go, why? She goes, because when you met me, I was overweight, I was pale, I was stressed, I didn't look good, I was unhealthy, I wasn't sleeping. My case is done. I feel better, I've lost weight, I physically have changed. And I don't want that picture representing who I was, the way I was representing who I am. I go, sure. We took a new picture. I gave her the old one. She tore it up. We put the new one in the file. She went on her way. And that physically shows you the impact we can make on people's lives. So I absolutely love this job, and thanks for the question. It's fantastic.
Great question. And you're all doing great work. So thank you so much for sharing that. And thank you for sharing all your knowledge and insights today and for your time. Thank you to all of our speakers. We also want to thank all of our audience members who joined us today. I know we ran a little bit late today, which I think is a first for us, but it was a really great presentation, lots to cover and a lot of really great participation. So again, just want to thank everyone, and we hope to host you again next month at our webinar on May 8th.
Thanks, everyone.
Thanks for joining us.